Hey guys, this is Toby Mathis, and today we're going to be going over estate planning, what it is, what it isn't, and the typical types of estate plans you're going to see out there. Before we dive in, I want to just kind of touch base on what it actually means to be doing estate planning, because there's a lot of people that immediately assume it has to do with death planning. We think about what's going to happen when we pass away. And I want you to think about it, because while that's a component of it, your estate plan really should encompass things during your lifetime that may occur, probably are going to occur, and make sure that you're addressing those issues. So if I was putting your whole life out on a time spectrum, I'd be looking at it saying there's things that occur while we're living. There's a transition period where we might not be able to make decisions for ourselves before we pass, and then there's after we pass. Unfortunately, most people immediately go to this idea of a will or something along those lines that immediately just discusses transfer upon death. It doesn't really do anything for you while you're alive. And I think that's a huge mistake, because there's so many things that can occur to us while we're alive. So for example, we just went through a pandemic. During that pandemic, there was people that needed medical attention, that were incapacitated because of the medical attention, and had a variety of other needs. So for example, if you went into the hospital that had a do not resuscitate order, and you did not have somebody who was able to act on your behalf through a valid power of attorney or medical power of attorney or medical directive, depending on the state. They're called slightly different things, but it was really just empowering somebody to act on your behalf if you were unable to. Then quite often you were at the mercy of whatever the rules and procedures were for that particular medical establishment. Now, I'll just say this. We all need advocates. We need advocates that know us or that will act in our best interests. I'm not saying that a hospital won't, but I'm saying is that if you want someone who's personally involved with you to stand into your shoes and to advocate for you, you need to empower them to do it. Now, quite often, if it's a married couple, you're going to think automatically a hospital or a doctor will immediately start looking at the surviving spouse, and they could. I'm not going to say that they don't. I'm not going to say that they just play a hard rule, but you're rolling the dice on that one. And more importantly, if it's somebody other than a spouse, you really do need to make sure that it is in writing and that they are empowered. And when I say empowerment, I'm not just talking about giving them the authority to act on your behalf, but the authority to access information on your behalf, something called a HIPAA release, and access to the medical information, so that a medical provider does not feel like they're exposing their license and their well-being, their financial interests. They're not exposing it to possible dings getting hit because they unintentionally disclose information. So quite often, they are not going to share information unless they know that they have their T's crossed and their I's dotted, and that they can share information with somebody who's authorized to receive it, lest they be fined or subject to any sorts of discipline or civil sanctions or punishment, right? So we do not want to put somebody in that situation to where they are concerned about whether or not they can share information. We've seen this, by the way. We've seen this where medical providers that were covered under HIPAA shared information with folks in a shared living facility, for example, and got themselves in all sorts of hot water and ended up costing them tens of thousands of dollars. So most folks are going to err on the side of keeping the information close to their vest unless they have an adequate disclosure. And that disclosure generally is in the form of a power of attorney, advance directive, medical directive, something that says, if something happens to me, this individual has the ability to act on my behalf, and medical providers are authorized to share information, my medical information, with that individual in that while they're doing that, right? So, and you could have these effective upon incapacitation. You could have these effective immediately. Chances are, if it's somebody you're married to, you don't care if it's immediate or not. If it's somebody else outside the family, you probably want to make sure that it's effective upon incapacitation, so that it's someone can't just go and get your medical information without you wanting them to. So that's number one, is that we have things that occur with us. Number two is we have things that occur with us that are financial, and that's called a general power of attorney or a financial power of attorney. That should also be in your estate plan. And unfortunately, a will is not that. A will, again, only takes place when you pass away, and it covers the distribution of assets. We'll go over that in a little bit. But we really do want to have a document that during our lifetime gives somebody the authority to act on our behalf if we are unable to act on our own behalf. So if I am incapacitated because I am, maybe it's during COVID, maybe I'm incapacitated because I'm very, very sick and I'm in the hospital for several weeks. I need to have somebody who's able to pay my bills, talk to my creditors, transact business on my behalf while I'm not able to. Or worst case scenarios, let's say that somebody has Alzheimer's or a medical condition that is debilitating and they're not able to act on their own behalf. This can take place and be in place for years while somebody is still alive, but they're not able to act on their own behalf. And it doesn't just have to be comas and things like that. If they are incapacitated and unable to care for themselves in that manner, it's important to have that financial power of attorney so somebody can advocate on your behalf. I've dealt with these numerous times where, thank God, we had something in writing before something happened, because it's generally too late, or you're dealing with some sort of conservatorship or guardianship provision after somebody's incapacitated, which is costly, time-consuming, and a mountain of paperwork. It's so much simpler if I just put that power of attorney for financial matters, or what's called a general power of attorney in some states, and put it in place, and it can be effective again when I'm incapacitated, so I don't have to worry about somebody doing anything with my affairs while I'm alive and able to care for myself. But the second I'm unable to care for myself, somebody has a mechanism for stepping in and acting on my behalf and acting in my best interest. So there's two very simple ones. And I would say that it's the medical and you have the financial. And in the medical one, we have not only the power of attorney, but we also have the medical release, the HIPAA release. Now let's get closer to passing. Now, we're all going to do it. Every one of us has a timeline. But what happens towards the end? Do you want to have extraordinary measures taken to preserve your life? Do you want to be able to go out on your own terms or have somebody advocate for you to where they're able to discuss the pros and cons of certain types of procedures or medical attention? And maybe you say, I don't want to have extraordinary measures taken to continue to preserve my life under certain conditions. And you want to be able to give somebody the authority to act on your behalf. That is called a living will. Not a living trust, a living will. Not a will, a living will. It's for end of life decisions. And it's where you're empowering somebody to pull the plug, discontinue nourishment, or can get together with medical providers and make decisions as to what level of care you're going to receive in your last days. This is really important because it's frustrating, not just from the family standpoint, it's frustrating from the medical establishment standpoint too, as to what level of care. Now, I've been a court-appointed guardian before. I've been to loggerheads on this precise issue. And in some cases, I'll give you one real-life example, was a gal that I represented for better part of, I think, 11 years. And on 3 different occasions, there was discussions about terminating life-giving care. And in all those cases, I had written directions from the client who that I was acting on her behalf. And in all of those cases, we were able to preserve life. And the interesting part of this one, and I wouldn't have believed it had somebody told me this before, that this was going to happen. She died in natural causes in her sleep. There was actually 3 occasions over 11 years where there was recommendations to terminate life-saving care because they did not believe that it was going to be successful or that she was going to be in such a condition that it wasn't fair. In all situations, she recovered fully. So I just say that because without having the ability to have those discussions and to do a little bit of pushback and digging and knowing the individual and knowing what her values were and what she cared about and being able to say, here's what she told me, it would have been a very difficult situation now, especially if it's a loved one, because you don't want to be in a situation where you have regrets about what happens. And you don't want to put that burden onto somebody else as to whether they're second guessing. You want to make sure that you're clear that, hey, this is the level of care I want. Do I want extraordinary measures? Do I want all measures? Some people are like, absolutely. And then other people are like, no, if it's like, if I have terminal cancer, please let me go, that type of thing. And then again, you're able to communicate with the medical provider and take appropriate steps, and somebody's empowered to act on your behalf to make sure your wishes are cared for. But you want to make sure you're articulating those. There's nothing worse than when somebody gets to that point and there's nothing, and people are guessing, kids are fighting, spouses are frustrated, they're concerned, they feel guilt, and you just want to alleviate that by putting something into writing. Now, notice, we haven't even gotten to the point where you've passed away. Estate planning is so much more than die and distribute. I'm not a big fan of the die and distribute, by the way. I've seen that do more harm than good, especially in folks that have larger estates or have active businesses and investment properties. One of the worst things you could do is just hand it to somebody. There's a number of reasons why you don't do that, but probably the most interesting to me was when I started digging into the facts, is that the vast majority of the wealthy weren't born that way. It's about 5% that inherit their wealth. The vast majority make it. And they have this old adage that the first generation makes it, the second generation maintains it, and the third generation blows it. In other words, if you give it to somebody that's not prepared to handle your estate, there's a good chance that it's going to be for waste. And so I tend to look at things a lot differently in saying, hey, if you built up something that's an income generator, allow it to exist for hundreds of years after you've passed and to continue to bless your future generations. You don't have to just give it to somebody. In other words, you may have kids and you feel like this compulsion, hey, if something happens to me, divide everything up with the kids. Not necessarily a good idea. For one, it's now theirs. They get into a divorce, or they get into a lawsuit, or they get into it. All of a sudden, you have no say. Your estate's gone. Or if they make bad decisions, you leave, you work your tush off, and you make a nice estate, and they receive it, and they sell everything off and buy a Ferrari and buy a house they can't afford. 4 or 5 years later, they're in bankruptcy. Who caused it? Well, I hate to say it, but you probably brought about that situation because somebody wasn't prepared. So how do you handle that? That's where we get into legacy planning. And personally, I think everybody can create a legacy if they want. And it's about putting your values into writing and carrying them out. Now, popular in the United States is this idea, if I die, distribute. And they'll use a will, and they'll say, who gets your stuff when you die? Just don't think that's a good idea. Number one, if you have a will, you are guaranteed to go through the probate process to litigate that will. And what I mean by litigating that will means a judge needs to sign off on the distribution of those assets. It's a grease slide into the probate process. What is the probate process? It is a legal process, just like a regular trial. It can go for years. It could be as low as 6 months. Generally, that's probably about the lowest shortage period, unless you have a really tiny estate. But generally speaking, you're looking at an average of somewhere between 12 and 18 months, according to AARP. And it's going to eat up approximately, and I could just say approximately because there's been studies of a typical estate, somewhere between 15 and 20% of the estate's going to get eaten up in the cost. Now, a lot of you guys are already jumping up, hey, but I heard probate's easy in my state. It's always easy unless there's a dispute, and there's always issues and disputes when there's money involved. There's, whether it's coming to the surface and boiling up and being brought about by litigation. I just see that, somebody once told me this, and I'll just share this with you because I think it's true, is you're acting your worst on your worst day when you're going through probate. You're acting your worst on your worst day. It brings out bad behavior in people who are otherwise really great people. And I've seen it over the years. I've been involved in several. The other thing is, if I do it this way, and I'm just doing a die and distribute, I may disinherit my kids. And I know nobody intends to disinherit their kids, but the way it happens is no different than what you saw. If you're familiar with Anna Nicole Smith and her story, 28-year-old Playboy playmate, married a 90-some-year-old gentleman whose wife had passed away. She married him. He immediately passed away, not long after. And the kids, of course, were ticked off because now she got everything. I've seen this over and over again over the years. Had it actually happened in my family, where somebody unintentionally disinherits their family because they leave everything, to their spouse remarries, leaves everything to their spouse, and the kids get disinherited. Even if you don't have a will, it's called passing away intestate. And if you pass away intestate, then the laws of your state control. And you can go Google Prince and see what that looks like. Years and years of legal wrangling as under state law, they're trying to determine who the heirs are. And frankly, avoid it. I would just say avoid it by using a living trust. A living trust is the way out of probate. If you die with a will or without a will and no trust, called intestate, you're going through probate. If you pass away with a living trust, you're avoiding probate. And you can put in provisions that say, hey, if somebody fights, they're disinherited. Putting a little teeth in that thing so that we can keep people in check. We can also be clear about what our values are and what our intentions are with our own estate. For example, we could say, keep the estate in place. I have real estate that's generating income. To my trustee, pay the income to my beneficiaries, or better yet, use health, education, maintenance, and support. It's called a HEM standard. And you could designate a bank's wealth department, trusted individual, CPA, an attorney, family member, somebody who's not a beneficiary as the trustee, and say, could you please manage this for the benefit of these individuals? Banks do it all the time. And you just say, hey, when money comes in, here's the standard that you're going to use for whether or not to make a distribution. So somebody could get money if they need it, but they don't get to just take the money and buy the Ferrari. I always explain it that way. It's like you could have it to where nobody's entitled to go take anything unless there's a rationale for it. And what ends up happening is your estate tends to grow as a result. And if somebody looks at it and they say, you know what, I like that. It's there for education, maybe for schooling. If somebody gets sick, there's money there. If somebody loses their job and is in danger of being homeless, there's money there. There's money to help them. And they might just say, I'm going to leave my estate to your estate, right? Hey, I see that you created this great document. I'm going to use the same terms, or I'm going to fund it and leave my assets to the same thing. And that's how you create a legacy. You want to talk about a legacy that's going to last hundreds of years, where I tend to draft documents. We have a 365-year statute. You could say, hey, that there's money there. Again, I use health, education, maintenance, support, but I could also put in things like, hey, I want to fund everything. Maybe it's a mission every year to another country, or maybe it's just visiting another country. Maybe you believe that it's important for people to go experience other cultures. So you just say, hey, my beneficiaries, I'll pay for a week, 2 weeks out of the country, subject to the discretion of my trustee as to the level of spending. So not going on a lavish holiday, but maybe they're traveling to another country. Maybe they're going to Europe. Maybe they're going to Africa. Maybe they're going to Asia, whatever the case. They're able to get that benefit because of you. And I always think of it, that would have been really cool if grandma and grandpa did something like that was there for my family. That would have been really interesting. I would have thought, like, geez, I've been around people that had trusts set up that enabled them to get their education. I remember them going through school without all the stress. And I was like, that would be cool. But this would also be very cool, something like that. And again, the sky's the limit. You get to decide what it is that you're leaving. If you want to leave it, you could put training wheels on this that says, hey, I want to distribute it to my kids, but how about 25% when they're 25? How about 25% when they're 30, 25% when they're 35, and the rest when they're 40? Something, just put it to where they're older in life. I tend to, again, be on the side where, especially if it's a sizable estate, that I'm stretching it out over a long period of time, because I don't know what's going to happen in the future. Nobody has that crystal ball. And I want to make sure that I don't unintentionally harm people. And there's been a number of studies. I tend to use one during the events. I use the Ohio State University study on windfalls. A lot of it's lottery winners. And what we see is that if you give somebody who's not prepared for money a bunch of money within 4 or 5 years, they don't keep much. It's on average, it's about 16 cents on the dollar. But worse, their level of bankruptcy exceeds the rest of the population as a whole. So the median amount of bankruptcies, they exceed that, even though they were given the windfall. And what I look at it is, if you're not prepared for money, it can certainly cause you to change habits that you cannot recover from. Buy the big car, buy the big house, all the expenses that come along with it. By the time you realize you can't afford those things, and the utility bills and the property taxes are killing you, or the upkeep on the vehicle, by the time that all that's said and done, you're in over your head, you're not able to recover, and you end up in a really bad spot. Really bad spot. And you compound that if you have anybody that has alcohol or drugs or issues like that. Frankly, we just don't know what the future is going to be. So rather than leave somebody something that ends up being a curse, we want to leave something to somebody that's going to be a blessing. And you can absolutely do that. Now, I'm just going to take a quick time out here. We talked about during our lifetime, towards the end, and then after we pass away. I'm not going to say don't do a will, by the way. I'm going to still have a will. I may use it for guardianship provisions for children that are under 18, something that I want to put in a court. I may use it for burial directions. Do I want cremation or do I want burial? I may do that because I'm expecting to put that in front of a court. And if I have to put it in front of a judge. And I may still want to file a low asset or no asset probate just to make sure that there's no creditors, because I can freeze out all creditors of the estate over a certain timeline, depending on your state. It might be 90 days, it might be 108 days, where nobody can make a claim in the future against the estate. But what it does is it names one beneficiary underneath that probate. So there's a public record for all probates. Now they don't know who gets what. Instead, we just leave the living trust as the sole beneficiary. Now they have no idea who received what items. Something that we don't think about a lot is that probates can be easily researched. And if you have of means, substantial assets, people are going to know exactly who got what. If it's a probate, if it's a living trust, is completely private. And sometimes people forget that. Now, I bring all this up just to kind of break it into pieces. We talked about our lifetime, towards the end of life, and then after we pass. Anybody can set this up. A lot of folks go into a lawyer's office. The lawyer says this is for the rich. The type of plan I just mentioned, by the way, when you have a living trust that goes on for generations, it's called a dynasty trust. And there's people that used to sell those things for tens of thousands of dollars. For us, it's just a living trust that lasts a long period of time, because that's exactly what it is. It doesn't require any hefty amounts of money. These things are all a lot less expensive than probating. My experience is that probating is significantly more expensive than any level of estate planning. But let's just say that you don't have a ton of money. You're making it and you're looking at it and you go and you talk to a lawyer and they say, I just don't think your estate's big enough. That's the person you walk out on. Because the way I look at it is that if I hired up, let's say I hired ADT to get an alarm system for my house, and I was worried about the security of my home, I would not expect an alarm technician to walk into my home and look around my house and go, you really don't have anything to protect. You don't need an alarm. What I would expect them to do is get me an alarm system because I want it for my well-being. When I go to an estate planner, I don't need someone to tell me, oh, you're not big enough. No, please do it, because anybody could set up an estate plan. And if you have a good idea and you have values that you want to carry on, you have a life. All you have to do is insure that life. So if you don't have the money right now and you're worried, what if I set this up and I don't make a ton of money? Just insure yourself so that the money's created just by your passing. Get a term policy, get a whole life, get an IUL, get something. And then the estate plan gets funded when you pass away. I think that's just, that's fine. So if you're a young person, especially you have minor kids, make sure you have an estate plan. But if you're a young person, you don't have a ton of money yet, even if you're single, I've seen this before. I've seen single people get sick. And then who's there to pay for their stuff? Nobody. And they end up getting their credit trashed and everything else. I've had folks that were down for 1, 2, 3 months. I had one gentleman who actually contracted a brain fungus, was down for 6 months. His mom was going crazy because his properties were being foreclosed on. People were taking action against him, and nobody could step into his shoes and act on his behalf. So even if you're young, you still want to have something, but you can always fund it later, and you could tie it to your life insurance so that, hey, if I get a policy, I got $100,000, great. And what does it do? It dumps money in for maybe I don't have kids. Maybe I just care about organizations. Maybe it's animal organizations, whatever else. Now there's money here that's going to be continue to be paid out to them over a long period of time. And you can give your estate direction, and you could craft what you want your estate to look like and grow into that estate. There's nothing wrong with that. I'll never understand why more people don't do it, because everybody needs that power of attorney. Everybody, I don't care who you are, especially if you're single, you want to make sure you have a power of attorney so somebody can go in there and advocate on you. Power of attorney for health, I should be very specific. Everybody needs to have a healthcare advocate. Everybody needs to have a medical or a financial advocate if you're not able to care for yourself. Everybody needs to have a plan. Period. Full stop. Anybody who says that they don't, I don't think they're being serious. I don't think they've seen what typically happens and what could occur. We just went through this massive pandemic where we saw so many people affected. Yes, it can happen to anybody. And we want to make sure that we have advocates so that you're not on your own. So during your lifetime, transition at the end, and then our estate, the simplest thing is to do a living trust because it encompasses all those documents. The next simple thing is to at least cover one of them, right? If you do a will, I always say this, will versus a living trust, they're just two different animals. I always say yes, a will and a living trust, please, because I want to have the pour over will. I still want to have it there, but I need the medical power of attorney. I need the financial power of attorney. I need the HIPAA release. I need all the little ancillary documents that go along with it because it is my life. And I want to make sure that I am being very specific about who I am entrusting to act on my behalf, and I'm empowering them to do so. It's very, very critical that I look at all three of those stages, not just at the end, not just what happens when I pass away. You're going to make a mess if you do that. You're going to make a big mess if you have a large estate and you're forcing your heirs to go through that probate process. Please don't do it. Just get a living trust. Make sure you have your power of attorney for financial. Make sure you have your power of attorney for medical. Make sure that your medical power of attorney has access to your medical records through a HIPAA release. Just put things in writing. Once you do that, it's so much easier. And by the way, if you do that once, you live your life, you don't have to redo it. You can amend it. You can make small changes to it. You could even restate it, but you don't have to go through and say, I'm going to start from scratch. With a living trust, it's basically a contract between yourself, and yourself. You're the trustee, you're the beneficiary, you're the grantor in the beginning. And if something happens to you and you can't be the trustee, there's a successor. Something happens to you, you pass away, you can no longer be the beneficiary, there's a successor. That's all it is. It's actually fairly simple, makes a lot of sense, and I hope you understand the wisdom of what it means to actually put together an estate plan, and I hope you're able to put one together. Thanks.